Right out of the gate, this hearing isn't about guilt or innocence. It's about freedom until trial. And in court, that's a high-stakes chess match where the opening move can set the tone for everything that follows.
We're going to be requesting that the court set a date for Mr. Pearson's exam, and we'd also like to address the issue of bond when the court's ready.
You have all discovered?
Yes, to my knowledge.
People have their witnesses available the 8th?
We'll do it, Mr. Chairman.
Preliminary examination in person, July 8th, 2025, 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor. May I address that?
You may.
Your Honor, our client has informed us that he has no prior convictions and he was extradited from the state of Missouri where he resides. He is willing to stay on a GPS tether and remain in the state of Michigan, or alternatively, he can leave the
so
state.
We had to extradite him?
Yes.
Hey, go ahead.
Or alternatively, he can leave the state of Michigan and not return, and he's willing to do all of his court hearings over Zoom. He does have employment.
Why would we do that if we extradited him?
Translation: the judge is saying, we went through all the trouble to drag you back here from another state, and now you want to leave? That's the legal equivalent of borrowing someone's car, returning it on empty, and asking to borrow it again.
I mean, what? Did he waive extradition? But we had to get him here, right?
Yes, sir.
So if we had to bring him from another state, and I'll wait for your answer, why would I let him leave this state? And why would I let him basically be out of custody at this point?
Well, Your Honor, he's willing to stay in state on a GPS tether.
But he wasn't willing to come here to address these issues.
Yeah, he waived.
Go ahead. I'll let you complete your argument for the record. But
Okay, thank you, Your Honor. I appreciate it. We were just requesting a personal bond, or if the court was not inclined to grant this, a lower bond with a 10% option.
okay. I don't need a response, but thank you for standing. Motion for bond reduction is denied. I think it's rather evident on the record as to why the court is denying that. So his bond is denied. The exam is set for the 8th. Thank you.
Thank you, Your Honor.
Call the case of the people versus Barrage Scott.
Please, Judge. Court shall feast on behalf of Mr. Barrage Scott, who is approaching the podium. Mr. Scott, please state your name for the record.
Rise Dante Scott, sir.
How you doing, Barrage?
All right, just glad to see my family in here. That's all.
Thank you, Judge.
Been here every time for you. All right.
Thank you, Judge. I believe this is a competency review. My understanding is that we do have a report that is competent, Your Honor.
Yes.
We stipulate that, Your Honor.
And the people?
We'll also stipulate.
All right. The court, having reviewed the report, would find that the defendant is competent to stand trial. The defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is found competent.
Judge, I'd be asking the matter be set for a PCC, and Mr. Scott would like.
Competency doesn't mean the defendant is innocent or mentally healthy. It just means they understand what's going on and can work with their lawyer. Think of it as passing the "can you follow the plot" test in the courtroom drama.
To address bond as possible.
All right. Probable cause conference will be set for July 10th, 2025, 9 a.m.
Thank you, Judge. I've had a chance to talk to Mr. Scott about the situation, and I've relayed to him how serious of a charge he is facing. Mr. Scott is still asking that I seek a personal bond from on this case, Your Honor. although the court does see that Mr. Scott is competent, Mr. Scott does indicate that he suffers from a variety of mental health conditions. He indicates that he would love to get this situation resolved. He would love to see if his prosecutor's office potentially offer him a mental health court resolution. He says that he's not going to run from this situation. He has family support. He indicates that his mental state is in a much better place now than it was at the time of this alleged event. He indicates that he has a grandmother who is involved in his life and who will help make sure he attends any and all court dates. He indicates he will go to any outpatient or inpatient treatment that the court does require. He also has no objection to being on a tether.
Notice the strategy here. Defense is painting a picture of structure, stability, and compliance. In bond hearings, it's less about sympathy and more about convincing the judge you're a safe bet who won't vanish or reoffend.
He indicates he's willing to just address everything that's going on in his life, Your Honor, that he will not be a problem for Your Honor should the court release him. He's asking that Your Honor could consider a reduction in bond or a potential personal bond. But again, I have relayed to him how serious of a charge he's facing. But I believe that's what you want me to argue. Anything else? Mr. Scott says that he's on his medication now, and he's obviously much better when he's on his medication than he is when he's off his medication, and he will stay on his medication should the court allow him an opportunity to be released. And that the nurses in the jail have upped his medication in certain areas and had him on a shot and a pill form.
Yes.
And so his mental mind frame is in a better place, and he will do anything and everything the court asks if he's asking for potential release.
Response.
I would ask that bond remain as currently set. I appreciate Mr. Easter's advocacy on behalf of his client. I'm struck by the language in the competency report. Mr. Scott affected a volitionally cooperative response out during the evaluation process and attempted to feign legal knowledge, memory deficits, and symptoms of severe candidly, if you're uncooperative in the underlying competency evaluation, given his criminal history and the facts of this case, I believe that he is a danger to the community and has severe handles.
Nothing further, Judge.
All right. I am going to deny the defendant's request for a bond reduction in this case. I think the bond is set appropriately. I would further indicate that
That's a credibility landmine for the defense. Judges have long memories. And if you've blown a chance before, it's like showing up to a job interview after ghosting the last one. Your odds just tanked.
Mr. Scott's been appearing before this court for quite some time on various matters. And typically I can let Mr. Scott out of custody, may come back in, but usually for minor things. Mr. Scott was in custody. I took a chance, released him. He did not make it a week before this came up. Mr. Scott was arrested. So I'm not going to take that chance again, especially since it's
You understand what he's saying to you?
violent case.
Hold on, do you understand what he said to you?
So
He said that he let you out. This happened a week later.
I know, but he keeps saying the same thing.
Okay.
Saying the same thing that he's saying.
Okay.
He's not.
I believe Mr. Scott wants to address you directly, Your Honor, if you
go ahead, Mr. Scott.
Listen, Mr. Simpson, I know you kind of keep, going back in the past, right? But this is my life. You know what I'm saying? My grandma's here, my family's here. People are making me look bad. Even a competency hearing, they're making me look bad. I answered everything what I was supposed to answer the right way, and the prosecutor saying I was I wasn't cooperating the correct way, and I was. It seems like I had to take 2 competency tests. And the first one, he just said what he wanted to say. I'm asking if you release me today, because I gotta go see Slay today. They said if I do get released, they're gonna follow the same recommendations you will follow if they put me on tether, if they put me in. You never put me in no classes. You never ever put me in no classes or try to do anything like that. I want my days to be filled. If I'm on tether and I have a curfew, I want my days to be filled. I be with my auntie, stuff like that. I go to classes. I go to Don Farms. You know, I need this. I need help. I have a drug problem. I never addressed it like this. But after my sister died last year, she died. She had passed away at 23. I went crazy. I didn't understand half of the things. She had heart failure. You know, it's my grandma. She's 70 years old, something like that. You know, what it happen if you keep me in here and then she just something happens? No, listen.
Mr. Scott, no, you listen. You listen.
But
I'm done. I let you out. I gave you a chance. I've given you numerous chances. Saying that anybody's trying to make you look bad, I don't have to go to the past. I let you out. You don't make it 8 days. And now I have you involved in a crime that involves pointing a gun at another person. I'm done.
what do you mean? Listen, can you just let me
Motion for bond reduction denied, bond will continue.
Thank you, Judge.
But you ain't let me.
And there it
She's
is, the
70
final
years
gavel
old,
drop.
something like that.
When a judge says,
what
I'm
it
done,
happen if
that's
you
courtroom
keep me
code
in
for
here
this
and then
conversation
she
is
just-
over.
Something happens.
At this
No,
point,
listen, Mr.
the
Scott,
defense
no,
could
you
quote
listen.
Shakespeare and juggle
No,
flaming
you
gavels,
listen.
but the decision
I'm
isn't
done.
changing.